it is celebration time for the family of Letils. 250th session. When we started off during the COVID times, we never even aspired for 50, 100, 150, 200, nothing. But because of this weekend get-togethers or the earlier day-to-day get-togethers we had, it has become a part of our extended family. We have been discussing, deliberating, and at times we had our own conflicts on certain issues, but still, end of the day, we all go back empowered. Today, it is a momentous occasion for the Letils family because it is our 250th session. We are privileged with the presence of dignitaries who have been the faculty in our earlier sessions, Justice Ramkumar sir, Justice Rajendran sir, Justice Ashok Menon sir, Justice Ramakrishnan sir, Vijay, P.S. Narayana sir, K. Vijay Rao sir, all of you. I mean, it has been a wonderful journey of empowerment, enlightenment, and exchange of ideas. Today, we are privileged with a wonderful speaker. We are indebted that Justice Thottathil sir has agreed to address us on this momentous occasion. And this being a thoroughly informal platform, I would only request Justice Ramkumar sir, who has been the pillar of support, our inspiration, and usually I dub him as the backbone of this entire program, whether he likes it or not, but still, sir, it is you who has been inspiring us to go ahead with your introductory remarks. Let us start the session. Ramkumar sir, please.
My back pain is yet to subside. After the fall.
That is thanks to Neil Kamal chair. You should not sit on plastic chairs, sir.
Yes, I have learned a lesson. Good evening, friends. I have great pleasure in welcoming today's speaker, Brother Justice Radhakrishnan, to our fold, where we talk sense and nonsense, but only forensically and unbridled by any binding or biting precedents. Myself and Brother Radhakrishnan are elevatees of the 2004 batch. We have not met each other for a pretty long time. I confess that I am not active in the former judges platform, as well as in the High Court Lawyers Collective. This may be mainly because of my inhibitions and angularities. Moreover, in those plans, I have little scope for sharing my experience and knowledge to the bench, bar, academics, and the posterity. I still do not know the future plans of Brother Radhakrishnan. Gifted with a golden tongue, he has the felicity of language and a profound knowledge of almost all branches of law. I hope and wish that he sets up practice in the apex court and render human service to the nation. Today, we will be hearing him on the changed scenario of lawyering and judging. COVID-19 has at least given us one blessing in disguise in the sphere of webinars. Sitting in your home chair, you can go to any part of the world and render an erudite lecture or hear eminent personalities in every walk of life. I don't say that there are no demerits for the system, which is now in vogue, but we have to face extraordinary challenges to combat extraordinary situations. My judge days did not witness any virtual hearings, which the current generation is very much familiar with. I do not have any first-hand knowledge about the prevailing scenario. Let us now lend our ears to Brother Justice Radhakrishnan, who has experienced both pre-COVID and para-COVID hearings in court. Over to you, Brother Radhakrishnan.
Thank you, brother, so much, and also to the organizers who thought it fitter to. In fact, I was invited earlier, but maybe due to the pressure of work in Calcutta High Court, I could not join at that time. When I was asked as to what topic I would like to speak on, I recall days in the National Judicial Academy in Bhopal, when I and Professor Mohan Gopal used to exchange pleasantries, which of course kept me awake till about 2 o'clock in the night, when he used to say, our libraries are so filled with information, and so that you don't have to do your research and bring down your papers and quote the judges of India and abroad, or don't have to quote the articles, because it's all there, we can do that. So therefore, he is one who always prompted to look forward in the sense, try to tell us something what is happening now. and what could be done, the way forward. Almost, I'm sure that Brother Justice Ramkumar and other brother judges on the platform would recall the days in National Judicial Academy. Every conference ends with the last program, which is called the way forward. Normally, it's captioned as way forward. So I thought immediately that what we should be talking about is not any jurisprudence which is to be culled out from what had happened. Like Brother Justice Ramkumar very nicely put it, not on your precedents and not on trying to do your articulation on that, but then trying to say as to what could be considered to be done for future management of the different communities. When I say different communities, when we look at court, it is not merely the practitioner advocate or the litigant or the adjudicating judge, the three components. There are a lot of people who are involved. Maybe it's a fortune. Sometimes you get fortune through misfortunes. I'm one of those fortunate ones whom misfortunes had blessed abundantly, because I got the opportunity to hear the problems relating to COVID. Because I landed in Calcutta, within weeks, COVID came. And then COVID management became part of the job of the Chief Justice's bench. Every day, the first item was COVID management. Right from whether the COVID patient should be given a mobile phone to use, till ultimately whether the near and dear ones should be shown the human remains of a dead COVID patient. Well, whether you open the sip and show, or whether you close the sip and show, whether you permit water to be sprinkled, every little thing became a judicial issue on the judicial table, which of course the local self-government institutions and the governments had done their bit, and whatever it is, it had all come out. So what I'm saying is those misfortunes brought me the opportunity to see through as to what on ground are the problems. The second aspect of that misfortune's impact as a fortune in management of judicial institutions, which I learned, is how to craft the court. I have learned, and I've also been part of teaching what is called court craft. In olden days, we say the art of cross-examination. One of the basic principles in art of cross-examination, which I used to always say, is have the ability to look into the eyes of the witness without threatening. Elicit answers by looking at the face of the witness, showing him the charm of your face, if at all there is charm on your face, and tries to elicit the answers in such a way that the judge does not get irritated. I wonder how I would look into the charming face of a witness who is put to be for cross-examination on the virtual mode. So many other issues. Exchange of arguments between lawyers. I'm not sure whether any of you have seen the type of lawyering or advocacy which you have in some courts, particularly in the High Court at Calcutta. You know, it's not merely vibrant. It's also sometimes you need to pull down and say, you also need to raise your voice and say, come on, cool down. So in such a scenario, how do we really do in a VC or a video conference or whatever the platform? Well, then I thought that this is high time for us to think as to how do you really run the modalities, because I've come across in the international domain, there are nations where the entire system is bereft of everything except a small slot for oral hearing, where the oral hearing is permitted only to clarify what the judges have got to ask. Otherwise, you put in the papers, you should know how to put in the papers. You can't simply load bulk and bulk. I remember a Supreme Court judge who is even now a Supreme Court judge telling me one day, hey, Brother Radhakrishnan, look at this. One SLP against a bail order comes up 800, 900, 10,000 pages, and they expect us to read the whole thing on the previous night, maybe on a Sunday night or on a Thursday night. And he was saying, who expects? It's only a money spinning game. That's what he ultimately told me. Because you stand up and say something and I'm not demeaning anything or anybody, but the process is that even before the COVID had come, I was not sure that this is really a fruitful exercise. Well, to the satisfaction of the conscience, which is supposed to be the most important element for a judge. Well, having said that, I'm given to understand that the persons who are linked in for this program include from the bar, from the judges, from the academia, so many groups. Now, I would like to just indicate that we need to open up and think, not merely in relation to COVID, the post-COVID scenario, the virtual hearings, virtual courts, etc. The impact of COVID had aggravated the already slowed down judicial process in India. This is my perspective. Because we have already a challenge. We had a challenge, we have a challenge, we are always at the challenge of what you call as docket explosion, or what you call as a pendency in litigations pending in different courts, the qualitative and quantitative deficit in the outcome of the product which is delivered to people who are blessed with Article 14 of the Constitution of India. And the way things are going, when COVID really thought of visiting us, I think COVID actually thought that it's better that I go to these fellows so that at least these fellows can be motivated to do something better than what is happening. We have lost lives. We have lost lives. We have our heart going out and praying for them. But the situation is, we have already created an alarming. In fact, I was trying at one point of time in my career to find out where did this arrear of litigation, arrears, the story of arrears. I've heard good number of retiring judges at the time of retirement, they speak of the arrears that are mounting, that are mounted on the dockets, and so many things. But then I went back and I found ultimately that one of the judges, I think a chief justice of the then Travancore High Court, those days, he spoke in one of his speeches about the docket pendency, the pendency of litigations, the long pending list of pendencies. So this had been a problem, perennial problem. So this one huge issue of pendency, subject to this national judicial data grid and all those things which India has tried to push, this had got catapulted and got modified in its problematic presentation with the advent of COVID. COVID has added to the slowing down of the pace of the disposal of cases for reasons attributable to COVID. And COVID also gave us an inertia, which according to me is not that much required simply because of COVID. But COVID is also an excuse. Because I still remember when we were practicing in Kerala High Court, some of us youngsters got together and we said it's high time we create a small of nursery rhymes, like A for apple, B for basketball or whatever. So like that, we try to say from A to Z, can we not say something for adjournments? A for after a week, B for batter not paid, C for commission report not ready. So every day you have something or the other, whereby this gets adjournment itself becomes an issue. We have been talking about this before COVID. But after COVID also, I think it has really, please pardon me for saying that, COVID is also utilized. One of the utilities of COVID is also an adjournment. It has come to that sometime. So we have to tackle the post-COVID era, has to tackle the already pending huge backlog. What is the answer you will give to a fellow who has been convicted for 302, handed down life imprisonment? The fellow is in prison. The bench says that we don't have the time to hear an application for suspension of sentence pending an appeal, and therefore we think we defer you for hearing of your appeal. And then there is a queue system formed on the date of institution of the appeals for considering the final hearing. I have come across personally, I took over the criminal division bench hearing matters simply because of this in one high court. And I found 22 years behind with a life imprisonment order. And he didn't have anybody anywhere who could get him a parole or whatever. The chap was inside. There are a lot of fellows like that in India. I'm not talking about a solitary case. Statistics will show us. But the statistics, that such statistics will not be reflected in such data which we are otherwise getting from the national platforms. This is where the real work of this legal service, the so-called legal service institutions under the Legal Service Authorities Act and others will have to focus. Now, when I say this, I think that this program, if it brings about some sort of ignition in the mind of any person for that matter, I personally aspire to do that for the younger generation, the young bar. Before going into that, I would say that a particular challenge that the younger bar really faces on ground. Let us be frank about these things. Even Swami Vivekananda said, don't try to preach spirituality to an empty belly. I'm telling you, a God-given gift I have. I've been the Chief Justice of 4 High Courts, worked in 5 states, and I've seen how the little chotus, the younger ones, unable to make their ends meet in different states. I've seen tears in their eyes when they used to ask me personally, sir, what can be done? Because what happened as an impact of COVID was, let us be very frank, there were, I won't say wholesale exodus, but youngsters were on slippery foot. Seniors could not afford them. The law firms could not afford them. Where do they go? Occasionally, you see in some newspaper that a lawyer in Tamil Nadu has gone as a tea maker. One man has gone there, one man has gone here. What else can be done? You need the daily bread, not for you. People who look at you, your mother, your father, your wife, your child, your dependents. Maybe you'll remain hungry to feed them. But where do you get this? This is a stark reality. Nobody can say no. The Bar Association, the Bar Councils, all those supports are there, but you need to keep all this at the bottom line. The judges, with great respect, I would say, should also keep this in mind. Let me be very frankly, again, putting one more point. I'm repeatedly using the word frank. Bail applications, interlocutories, and mentioning matters in different high courts are essentially the breadwinning litigations for the younger ones. Many of them really know the law. Many of them really know what will happen to an NDP as a bail application if you file it before a magistrate's court. We see even very recently that in the remand magistrate's court, a bail application is filed and all the hullabaloo is made. And after that, it goes to an NDPS court. Again, something happens. Again, it goes to the high court, something happens. So even if you know all these things, these young chotus, the little ones, boys and girls, you tell them glorious things. We have the national law schools. We are bringing out high-level equipments in terms of the law libraries and research points, etc. But on ground, grassroots level, the Mafusal man's lawyer, the Mafusal convict's lawyer, the Mafusal woman's lawyer, the Mafusal child's lawyer. Where does the lawyer have his bread and butter? So this is an issue which I flag out at the first instance before we go into this other issue touching as to how do we try to manage the changing scenario in judging and lawyering. Having said that, well, if I were to draw a line of contents as to what are the contents on which I would flag off each issue or a bullet points on which I would speak, it's a typical what you had before COVID. Drafting your pleadings, speaking to your litigants, as far as the lawyers are practicing advocates are concerned. All those have become enabled by digital mode. One fundamental problem which need to be addressed in this stage is how does the litigant get the complete support as is expected from a lawyer to render justice to him insofar as client counseling is concerned, taking instructions are concerned, The lawyer should really know. And how do you really question the client and get the details? I've seen, in fact, after my retirement also, I've seen papers where bulk papers are sent to the lawyer. The lawyer keeps it for a few days, and obviously he will look here and there and have to say something, because after all, the lawyer is also a human being. Therefore, the points involved in a litigation have to be crystallized and precisely stated point-wise. You may call it bullet points, but these bullet points should be numbered if you are maintaining it in the virtual mode or even in the printed mode. I say this because even I at the bar had been trained at one point of time. We needed to do, even self-training was there, as to how do you put the summary of a case. You have to now, I think the rules of different high courts really require you to put a precise summary of case in the first page. But how precise it is depends upon the ability of the lawyer to download, cut, paste from the main pleadings. This is what I have seen in various states. I remember in the state of Andhra Pradesh, in one of the universities, I had to tell the young lawyers, this download, cut, paste syndrome has to come to an end. Because by that exercise, you don't really download any material to the real gray matter and white matter, where it should get arrested within your head. It doesn't come out with any idea being put from your brain. You're just doing a mechanized process. So what I would plead to the youngsters, learn how to write in the most precise manner and in a manner which will show is a chronological list. What do you say? Chronological list of events is prepared as if it is another ritual. Many cases are ultimately lost, or when I say case is lost, it is not a case of a litigant losing. It is a case of judiciary losing its opportunity to render justice in a particular litigation. Why? Because it is not provided with materials and data as is required for an adjudicator to adjudicate and deliver a verdict in terms of the laws of the land. This is fundamentally the problem. So the pleadings, the material evidence, the documents, all have to be properly presented. This is the first thing. Now, when you put it in a virtual mode, be very sure simply scrolling up the papers for the judge right on the screen in front of the judge does not really bring out any positive change unless the judge is able to quickly catch the points which are put enumerated. Whatever points the bar had been following earlier, only thing is the mode is now changed to the virtual mode. One additive which is necessary there at that point of time is a controlled mind, which will ensure that no surplusage, no unnecessary inclusion, no exclusion, which will be disastrous. And then maintain the pleadings within the format as is necessary to communicate to a reasonable, common sense human being, which I personally would expect every judge to be. This is all that is required. Person well informed in law, knowing the tools of his business of judiciary, he should be given the facts and figures and materials for the purpose of adjudication. If both sides do this, well, the first phase of the exercise will come to an end. Now, if it's a litigation which is controlled by the provisions of the Code of Civil Procedure, or it is controlled by courts, controlled in courts to which the principles of Code of Civil Procedure would apply, definitely the judge as an adjudicator is also duty bound to continuously keep applying his mind in the same systematic process of understanding the pleadings, of understanding the facts in such a way that if it is a civil litigation, by the time issues are framed, the judge will not show the courtesy or discourtesy as it may to the appearing advocates, requesting them to provide what is called in double inverted commas, draft issues, so that a sandwich could be made and eaten up before writing the judgment. I'm saying this quite strongly and emphatically because it is the bar which really brings out good adjudication, quality adjudication. It is not as if every judge knows the entire law. It is not a deficit of any particular human being. Every system requires its hard work to be put by persons at the relevant time, in the relevant location, in every litigation. This is how it actually proceeds forward. Now, the changing times of virtual courts and oral arguments in courts. There are two types, which is now called the pure virtual mode, like what we are now doing in this VC mode, either Zoom or otherwise. Then the next is what is called in different courts. Calcutta High Court had it for some time. In fact, they even now have it, the hybrid mode. What I had led the Calcutta High Court team to bring the hybrid mode there is to provide a video conferencing point inside the courtroom, connected to the judges who are sitting in their chambers. The lawyers are entitled to join from their own chambers, from their own residence. And I know some youngsters, very brilliant fellows, used to join from their cars. They used to park the car somewhere and join from their mobile. Fine. But why was a facility provided in the courtroom? The reason is there are people in India, there are young boys and girls in India among the lawyers who can't afford the type of a phone which will provide him the facility to make a video call, to make a video conference, to make a Zoom conference. And even there are also youngsters who prefer to come to court because they were told in good times that attending the courts and seeing court craft is very important to mold you and the way to bring you up in your career. And I know there are elders who always say, my lord, we would like to stand up and argue. We would like to come to the court. You provide your system for yourself. You judges may sit in the chamber, but we may stand and argue. So there are a lot of challenges every individual faces. So, and in video conference, whether it is in the court, whether it is a hybrid mode or whatever, one deficiency that I have found, it's a great, huge issue where I and my bench partner, we had to say that today's VC is over, enough is enough. We will join tomorrow. That's because the bar becomes sometimes a little either emotional or even a little bit of, once at the bar, among themselves also sometimes they start punching in the courts. If it is in the court, they can punch very well. But outside, when you have a VC program, if I assume that there are 5 lawyers appearing in a case and all the 5 start talking together through the VC mode, which judge is going to understand? I have faced this problem, especially when you have very vibrant and lawyers with high decibel and some 5 people appearing at the same time and through 5 VC points. And they also start talking at each other at such high syllable that you can't follow what is being argued. So ultimately, one day we had to tell them, okay, enough is enough. We can't follow you. We'll come back tomorrow. We closed down the VC. So, but this is, see, now you can, if you try to follow the national and international domain other than law, see how the international conferences throughout the world are being crafted in such a way, how the United Nations is functioning, how the other institutions of governance are functioning, intra-nation or international or intranational, either way, or even small issues, and go down to the institutions of learning, whether it is the law schools or the IITs or engineering schools or medical schools. The conferences are such that a person who opens his mouth gets the ear of the hearer. Otherwise, what happens is it becomes a market. This normally happens. So this is a very important thing that the lawyer will have to understand. The practicing advocate has to understand. Another aspect is interference by the judicial officer beyond what is necessary for understanding the case. That too, I think you should have, the judge will have to necessarily open up only when it becomes abundantly necessary over and above the written pleadings and written arguments which are presented. And if you try to put a judge tries to put a question, necessarily the lawyer should be given such time which is necessary to answer through the video conference mode. Then I think one of our brother judges here mentioned in the opening itself. One is unmute yourself, you have to keep on saying. Another is the hung mode, which I always had in my problem. That was a technical problem which I used to always face. Kya ho gaya? Hung ho gaya. Finished. That is the end of that day. So, but then you don't have to get emotionally upset over it. This is how the lawyer also, because I know particularly now, if last 1 week we had one particular case which was being bomb blasted by the social media and also by the regular media throughout India. But we also have the cases of the poorest of the poorer, where the lawyer also comes and says, sir, we are unable to get the connection. We are unable to get the link. We are unable to get. So this technology link issue is something which the head of the institution, whether it be the Chief Justice of the High Court or the district judiciary, the judges have to really put it down and find out and get things done. But I don't expect every judge to be tech savvy to that extent. But nonetheless, nobody should be able to tell us that we tried to do this, we are unable to do that. My postings in different states also brought me the blessings of being with the national computerization system at the national level and also at various different policy formulation, where we had to insist that, especially in these video linked matters, there are officers who are linked to the judiciary for the purpose of carrying out such work, but they are not judicial employees. Because it's a matter that the judiciary knows. We have other institutions which are linked. We don't have any disciplinary control. Some really, of course, to me, they have not done anything of that sort, but I've got complaints that they don't really cooperate. Sometimes they don't respond. But you need to put your foot down, and the head of the institution will have to definitely do that. Now, once that system is proper, then behavior, what I'm saying is behavior of the lawyer and the judges should be such that the purpose of the video conferencing or other systems, online modes, will have to be obtained by ensuring that there is effective, meaningful communication without meaning disrespect to anybody. This respect is a huge issue on which I have had very many situations in different high courts. I know a particular court where COVID became the issue. The lawyer got angry in court. His reaction to the judge was, take it from me, you will catch COVID and you will die of COVID. Fortunately, that judge is now the Chief Justice of a High Court. And the lawyer ultimately had given his written apology before a bench headed by me when we pulled him up for criminal contempt. See, these are, it's emotions will have to come down. Emotions will have to come down. It's not the old court craft which alone survives. So the court craft which the lawyers have, practicing lawyers have learned, the trial court, now trial court is going to have a huge problem, I'm telling you. Now, VC mode is going to be adopted for, even now, I think, now I can see Brother Justice Ramakrishnan here. Many of the processes, I think at the national level, I'm not sure whether the NGT does it. Many people, they have started using this for cross-examination, etc. Witnesses are in arbitrations. I know. I've been a retired judge. I know in arbitrations, video conference is used for cross-examination of witnesses. Of course, the demeanor and, once the amendment to the Code of Civil Procedure had come, it was a joke of our times that once the amendment came, the court craft which you learned, Like, how do you chief examine a witness? Has really gone, and there's nothing surviving on those things. Anyway, forget about that aspect of it. But once exchange of bullet noted points of litigation, exchange of points are done between the litigants or their appearing advocates and the judge, a very sober consideration of those points, and if necessary, by one or two adjournments, so that there is no gap created or all gaps are got filled up, so that the judge ultimately comes out with a real product which is worth calling the judgment of an Indian court or an Indian adjudicator. That is the process which really needs. Now, another aspect which I have found after the virtual courts have started is, excuse me, the virtual court assembles, both sides are appearing. One side would say that today I have filed such and such papers. Opposite side will immediately tell the judge, please direct them to give us a copy. I have often asked them, why do you require a VC for that? If parties exchange pleadings through email or other mode, get satisfied at the level of either the solicitors firms or the advocates offices which really appear in the litigations, then it becomes an easy job when you come to the court. But here, I know cases where adjournments are given repeatedly. Okay, then the judge also is driven to the wall. He or she is driven to the wall, nothing else to do. Hey, come on, you serve the copy. Then next day, the other gentleman will come and say, I've got the copy, but now I want to file a rejoinder. So this circus, which used to happen in the ordinary civil courts of India, much before the CPC amendments of 1970 and 76 and others later on, that still continues. And if you bring all those exercises to the virtual mode, this will become a disaster. We can understand COVID impacting the other organs of the body, but it cannot go to such an extent to impact the judicial organ of the state. Equally, one more very critically important. Now we are in an arena where various platforms, this tribunalization, whether good or not, that's a different issue. But tribunalization has come to such an extent and such state that there's a huge chunk of litigation going on there. The huge chunk of litigation. Along with that, now you have the GST regime in the taxation law, then the IT different, and the different layers and officers at different levels who are hearing these matters. All of them are definitely insisting on only video conferences. And if the practitioners do not get attuned to that process, if they say that I still remember when computerization was introduced among us in the judiciary, I know many seniors use, hey, are you trying to go put me to learn all these things? It's a different issue, but time has to go through. We know elders. I'm sure that I can't communicate even with my children unless I'm at least to some extent savvy with this because of the physical distance between them. The same thing happens in the judicial sector also. Now, certain challenges that I've seen and which not only tried to be remedied, it needs to be remedied, it has to be remedied. There's no excuse. There is no excuse on the face of Article 14. I personally feel so. There are tons and tons of interlocutory applications pending in different courts, in different jurisdictions, in different fora, maybe the trial side, the appellate side, and the superior courts. Applications for suspension of sentence pending criminal appeals. Long pendency. I'm not talking from the Kerala angle at all. I'm talking from a national angle based on statistics which I know. Then another critically important thing is bail application. Regular bail and anticipatory bail. Huge chunk of applications are just pending. What will happen if a bail application is pending, or if an anticipatory bail application? I think many of the brother judges are here, many others may be here who will know better than me. Every anticipatory bail is also coupled with something which is the way the chap goes somewhere. He surfaces only after the whole exercise. What happens? The bail application just keeps going, and an anticipatory bail application or a regular bail application once considered in the VC mode. And also when, at least in the High Court level, if there is change in the jurisdiction of judges, quite often, sometimes it does happen.
Connectivity problem.
Some connectivity issue. Interruption.
I think some connectivity issue.
Better inform him.
Not be knowing about it.
Fair enough.
Rectified.
This
This is the one disadvantage of video. Virtual sitting.
This is one of the major drawbacks.
In a light, it is one of the difficulties. I can say major. It's one of the difficulties. If you say it is a drawback, we will be tarnished as a person against the system. So it is better to say drawback.
2 minutes.
We have to bear with that. We have,
Yes, he has come. He has come. He has come.
Okay, can you hear me? Can you hear me?
Oh yes, oh yes.
Sure.
Yes,
This is one of the major drawbacks.
Yeah, no, I think we should take
that
it
is,
in a
that is
positive note. We should take this in a very
what, that is what we are discussing about.
Yeah, right. We should take this in a very positive note.
Yes.
If at all, I see this particular instance of the disconnect that we had now, lack of connectivity, I would treat it as an example of just a reminder to me the way one judge of the Calcutta High Court called me over phone and told me, Chief, what is this? I am not able to do any work for the last 4 days. The whole system is hung. There is no connectivity. Can you hear me?
Yes, sir.
Oh yes.
Yes, yes,
You're
yes.
audible. Yes. But see, he was so emotional, he forgot that I had demitted office as the Chief Justice of the Calcutta High Court at least 2 weeks before. He had my number, he called me. Then I said, brother, I'm so and so, I'm back in Kerala, I'm here. I had to tell something, I'm telling you, okay, then okay, tell me. So I'm only pointing this because incidentally it came to me the emotional pressure that human being. I know the chap he works so hard and he works and works and works and it does a lot of work. But see, as Brother Justice Ramakrishnan said, if we try to say something about this connectivity issue, then it is like we trying to criticize the system. No, but we need to have a system. I will share one more example. Of course, we don't want to criticize the national system. while doing the video conferences in Calcutta High Court, we had one litigant who used to join from the United States, from his residence. On one day, it so happened that his case alone could be heard because he had complete, clear, clean connectivity, like you are seeing a HD movie, whereas the others had a connectivity issue. So this is one huge challenge. Now, another important issue which I wanted to flag off, though it is not the post-COVID alone, it may be a pre-COVID issues also. There have been a lot of complaints about the bar unable to structure the arguments in such a way. I'm talking about the younger groups, who really need a little more molding. The structuring of arguments and presentation of arguments in such a way that the judge is able to write a clear-cut judgment, the manner in which, and put it in a shape, because recently somebody was saying that again a debate has opened up whether it is better to say the result of your adjudication in the first paragraph and then go around to explain the reasons. One way of writing a judgment. Other is follow the principle of writing the facts, law, arguments, appreciation, conclusion, and all those things, applying what is globally called as the flag doctrine. But whatever it is, ultimately, even now, whether it is computerized or not computerized, I think non-computerized, with great respect, the days when we had the typewriters, judicial officers of a separate breed of those days, the litigant could understand the result of the litigation in a very cleaner. I'm not being too critical about the verdicts that now come, but because the judgments are meant for the superior courts where appeal is provided, and also for the litigant to know what is what. Anyway, it is also meant for the public at large, because once a judgment is delivered, it belongs to the great Indian nation, we the people of India. But nonetheless, we have a problem. This download cut pay, unfortunately, I've had the opportunity to see this download cut pay syndrome coming to judgment making when e-filing is done. E-filing, when hard copies are filed, they say, come on, give us an e-version, because it is video hearing, or therefore they get a e-version. Once the e-version is there, either it is supplied in a pen drive or by an email. Ultimately, I have seen that, unfortunately, maybe quite rarely, but it shouldn't happen. This mixing up pleadings by using the technology and then giving a verdict. I know I've seen some decrees of some of the foreign courts. Particularly, I do not want to mention any nation, the so-called not like the third world countries like or the countries like India, which is now supposed to be coming forward with the lead roles. But some other countries which were always glorified as belonging to the hybrid and the high breed, not HY, HIGH breeds. Some of the judgments and decrees. I had the misfortune, with great respect, I would say, the misfortune to be required to read through a decree of divorce granted by a foreign court. Well, honestly speaking, it took at least one day for me to understand a 1.5-page document, because it's supposed to be written in the English language. I say supposed to be, and I think the word supposed to be, or the phrase supposed to be, makes all the sense of what I would like to ultimately say in that. Because now going up slightly away from it, of course, we have also got a lot of jovial anecdotes which came after the COVID era had come. Lawyers trying to do VC in their, different types of undergarments, or the way only the court works and nothing else is necessary. There's so many things. But keeping all that apart, I would like to fundamentally push for one important, critically important thing, which I had been pushing even when long before COVID came. Don't segregate and rate the lawyers, the young lawyers. I'm talking about the youngsters, the children, the kids of the system. Please don't classify them. The system should not be there to classify them and push it in such a way. I'm very sorry to say this. Who goes to the official court? Because when the eminent former Vice Chancellor, the erudite Mr. Menon, Professor Menon, came out with the system of the National Law School system that had really contributed to the growth of the quality education in law. But when we breed the quality products, we also have the large chunk of the grassroots level colleges, which those days we used to say in double inverted commas, the mushroom colleges, products and all those things. Honestly, I can very boldly say that I am also the product of a mushroom college. But ultimately, if this mushroom boy is unable to go back and work for the common man in his hometown, maybe in his village. In Kerala, if I say village, people will look at me. But outside Kerala, you need to use the word village. But don't underrate them. Give them the opportunity to grow. Give them the facility to grow. Don't give them simply money. Give them some opportunity to grow. This video conferencing, and as somebody was pointing out earlier today, this gives you an opportunity to participate in programs anywhere in the world. Gives an opportunity to you to move to any part of the world to do your professional work. I know people practicing in the Supreme Court now, who by reason of the COVID issues are sitting in their villages. Maybe they have the wherewithal to do that and getting the work done in the Supreme Court through the video conferences. Just forget about the Bar Council alone. There should be some system which generates support. It's opportunity that makes, nothing beyond opportunity. Not always parentage, not always lineage. So I believe that the post-COVID era can really grow up. We have had challenges. What happened to this world after exceptionally disastrous illnesses had come, invaded this place? Not only India, various nations. If we had got over all that, I'm not saying that we are going to get over COVID next year or so, but what we are saying is the challenge should give a positive impetus to what work had already been happening. Now, one very good way, the last word that I would say is one good way of assessing for yourself as to what needs to be done is just think. Do you think that the scenario would have been much better if COVID had not come? Do you think that the arrear management would have been better? The quality of judgment delivery would have been better? The quality of lawyering would have been better if COVID had not come? So while we crown COVID with all the thorns of the problems that we have now facing, let us also ensure that this huge challenge, like in the case of Jesus, has brought to us a great opportunity to show that even the blood that flows out of such wounds will mold the system to a better tomorrow. Thank you all once again for listening to me and also to the organizers for this opportunity. And I look forward to very, very good, positive approach by the youngsters and great contributions by the leaders of the bar, including the learned judges who are here. Thank you so much. Thank you. Jai Hind.
Thank you very much, sir. And in fact, thanks to Professor Mohan R. Bulla, we have select students from Kristu Jayanti College, Bangalore, thanks to Anis and Professor Kumar and the principal of Government Law College, Calicut. We have select students from Government Law College, Calicut. And thanks to Dr. Anju Pillai, we have from Law College, then Bhavan's Law College. Thanks to Sprega ma'am and KMCT Law College. Thanks to Prasanna madam. Sir, in fact, before we have the interactive session with the participants, may I request may I recognize the presence of Justice Kunjikrishnan sir and Justice CP Mohammad Niaz as well among us, and Ashok Menon sir, over to you for your comments. You'll have to unmute, sir.
Justice Thottathil B Radhakrishnan's address was remarkable. He's always a good speaker and a very knowledgeable speaker. And I think he spoke exactly what was required for the young lawyers to imbibe and do what is necessary. Of course, we had a lot of difficulties during the COVID times. And but I would like to say that this was actually a boon in disguise, because the transformation from the physical mode to the virtual mode was hastened because of this COVID pandemic. And particularly in matters like bail, which I was manning during the COVID period. The entire period I was on virtual mode. And it was very helpful. And many youngsters could appear in the matter, and they could present themselves without much difficulties. And being a bail matter, all that you required was the CD file and certain important documents regarding the investigation, and so it was a very smooth functioning of the court during the pandemic period. And I'm sure that this system will have to continue, hybrid or whatever it is, and I'm sure that the lawyers will definitely adjust themselves to this new mode of lawyering and court management. Thank you, sir, for your wonderful speech on this point.
Thank you, Justice Ashok Menon sir. Ramkumar sir, your comments, then I'll go to Ramakrishnan sir.
Excellent articulation, Mr. Radhakrishnan. It was a forensic treat for the young lawyers, budding lawyers. Highly educative, inculcative, and insightful. In fact, you have told them about the code craft. Of course, the requirement of being precise was not to the contribution of pandemic. Even before that, to be precise was the requirement of every lawyer. But then you have told us that some courts degenerating into the level of Mr. Arnold Goswami's news channel, where everyone will be shouting. And the judge in that cacophony will have to do nothing or shout higher. Beautiful, it was a forensic treat for the young lawyers. Thank you, Mr. Radhakrishnan.
Thank you, Ram. Sir, over to you, Ramakrishnan sir.
Really, hearing Radhakrishnan, Brother Radhakrishnan will be interesting always, because he will be taking it everything spiritually, Vedantic principles being involved, for the purpose of meeting the challenges, to make them as an opportunity to achieve the purpose. That is what the Justice Radhakrishnan has done in this case also. Probably that is the way in which he has been trained in several ways as a lawyer, student, and that way. Anyhow, whenever we are here in Radhakrishnan, we will be getting such a motivating, challenging, making you to think that it is not a challenge, but it is an opportunity for you to thrive. So that is one thing that makes this, the lawyer community also to understand the situation and raise to the occasion to meet how the challenges can be met as an opportunity to help the society to get the the required justice delivery system to come. But they see after some time, when I am trying to switch over to the physical mode, when I had an interaction with the Bar Association people and the lawyers who are appearing, most of them reluctant to come for a physical mode, because they are now, most of them are comfortable with the video system, though not I am. To some extent, I will have to say that, because it is very difficult to control them, as Mrs. Radhakrishnan has said. They may be arguing between themselves. And we may not be able to control. If it is a physical mode, we can say so-and-so lawyer, we know, we understood, go to the next point. But even if you say that you go to the next point, they may pretend that they are not able to hear us. That is one thing we find it difficult. Or when you put a question to them, they will say that we are not hearing your lordship. Then we say that normally I used to say that whenever we are putting the inconvenient questions, when we are in a physical mode, we can understand. But in a virtual mode, the easy escape is to say that we are not connectivity problem, your lordship, we are not hearing you. That is happening. One. Secondly, as regards the what do you call the submitting the written submissions, etc. See, when I was a lawyer, my senior used to say about his experience from the senior lawyers of the elder days, where the British judges were holding the courts. When something was given in writing, a judge told, see, Mr. Lawyer, because there was someone, Ramnath Iyer was arguing a case. He said, you have already given the written submissions that was given in the lower court also. It is very fabulous. Covers everything. And why do you want to argue more? Then he said, see, the only mistake I have committed was I have given a written argument under the impression that the judge will go through that and the judge will understand it. But unfortunately, that has happened. I don't want to commit the same mistake before the appellate court. So this is a way in which the humorous things have happened in the olden days. And written submissions have got its own, the advantages and disadvantages. That is there. But once a written submission is given, because I used to tell in because we don't have the oral evidence process in the NGT. See, whenever the CPC is not applicable to us, Evidence Act is not applicable because we are everything under the sun, we can take it. And also we can have our own method by which we can regulate the process for the purpose of achieving the justice to be delivered to the environment, because it is being an environmental issue. We will have to go for that. So whenever we ask them, they will give a pleading, small pleading. When written submission comes, it will be double than the what you call the pleading that has been provided, pre-reading that has been provided. Thereafter, he will start reading that. So how much time we will have to spend to hear all those things? And very difficult is when we are sitting in the court, we can be able to control them to some extent, as Brother Radhakrishnan has said. But now in the video system, we are not able to do it. Still he completes, we will have to keep quiet. Or we may not be able to control ourselves also from here, because we will have to get the assistance of somebody, the technical, so-called technical assistant, to control them. And external noises. Those are all the areas where these are all the, we can only say that simple, avoidable, and also the curable defects. We can't say that it is a problem as such. It is a curable defects which we can understand the system and then we can be able to achieve the purpose. But this is the area where we will have to still learn. We do not know how far the younger generation lawyers coming from village level or the professional level are getting all these facilities for the purpose of meeting the situation. Is there any system that has been provided to have such an opportunity of using this system for those people also to thrive themselves in the profession? Though we say in the Article 51 capital A that you will have to have thrive to the efficiency, to the excellent, to the excellence. But whether such an opportunity has been given in a situation that arises now is the one question, where the government as well as the bar associations will have to provide some method in the bar association to have that opportunity of utilizing the technology for the younger lawyers also to have an access to the justice delivery system to meet their need as to meet the ends, I can say. At the same time, provide some justice to the party who are coming to them for getting some redressal from the court also. See, this is the challenge, but we'll have to face it and we'll have to find out methods by which we can adjust. As Thottathil has said, at the time when video conference or the training program itself has started, we were murmuring why this is required. Now we are preaching for a, what do you call, the regular education system is required for every department. That is how we are thinking about now. That unless you have got a continuous education process, we may not be able to update it. Because there was a system available earlier, somebody to regulate you, somebody to guide you. But such an opportunity is not available for the younger generation. And they were totally depending on the technology. They are not applying as what is a gray matter or white matter inside, but they are only relying on the technology for the purpose of finding a solution for their problem before the court, even without understanding what they are presenting before the court also. This is one disadvantage we find when the technology is being overcoming the human intelligence. So this is the area where we'll have to be a little careful. The younger generation will have to understand these things, and they download, cut and paste. That also must go. That's also coming among the lawyers, the judges also. When if I find some what you call the stereotype type or stereotype litigations, the certain arguments that has been pasted in some other case or met by them in some other cases being imported by way of cut and paste. Probably sometimes on facts, it may apply or may not apply. That will be understood only at the time when the appellate judge goes through the judgment and find out whether it is relevant or irrelevant for the purpose of issue. Thank you very much. The eruditive and the way forward that has been put forward by Brother Thottathil on this issue. Thank you.
Thank you, Justice Ramashan sir. Justice P.S. Narayana sir, are you able to connect? Yeah, of course, please, sir. Narayana sir, please. You'll have to unmute.
You are still muted. Please unmute.
I think somebody is required to help him.
Yes.
He's tech savvy.
Yes. No, now again it has muted.
Sir, please unmute, sir. Yeah, please go ahead, sir.
You are able to hear me?
Yes,
Absolutely,
very much.
wonderful. Loud and clear.
Very fine. Whatever it is, I thought of hearing Brother Radhakrishnan. I was very particular because I could not meet him when he was here at Hyderabad. He is very practical and very frank also. As far as the issues are concerned, the way in which he had highlighted, I record my appreciation. These are all the real difficulties. In fact, Brother Ramakrishnan had further explained and he had added. These are all the practical difficulties. Really, I think we may have to think about the legal professionals, especially in subordinate courts, to solve these problems and to meet these challenges. It appears to be a Herculean task. Let us hope better. That's all what I can say. Okay.
Thank you, Justice Narayana sir.
Status quo in the sense virtual or going back to physical? If you say status quo, it is virtual now.
Absolutely. Now let us hear from the Advocate General Sriram sir.
Well, as usual, wonderful. I have fond memories of having appeared before the chief, and he has had a very pleasant way of addressing me. He would call it me Mr. Shyam, and then I was also the High Court Standing Counsel then. I have a couple of issues on a lighter vein. When honorable judges don't want to say anything criticizing the system from inside, and you don't let people criticize you from the outside on the angle of contempt, how will the situation ever change? Now, that is as far as the first issue that had come to my mind. The cut, copy, and paste situation that Justice Radhakrishnan referred to was in fact one of the instances in a vacate petition that was filed by one of the contesting respondents there. And the Chief Justice was sitting with Justice Ramasubramanian. And then it was at that point in time, he said this case has to be made a testimony for the pitfalls of cut, copy, and paste. Of course, as honorable judges, you would only talk of the advocates cut, copy and paste. Only we will talk about your cutting, copying and pasting from some other precedent, because all of you have, by your conduct, have relaxed contempt of court provisions here. So it's, as usual, wonderful. As usual, very, very grounded and an epitome of what Justice Radhakrishnan has always been. Ears to the ground and completely on brass tacks, and brings wealth of experience into every situation he deals with and addresses. It was wonderful hearing him back again. And namaskars to all the honorable judges. Everything was in light, was in a light sense. I hope to have an easy appearance before you all, if and when I need to appear.
Thank you, Sriram sir. Prasad sir, your hands are up.
Mr.
Yes, sir.
Shyam, can I just put a sentence across to what Mr. Sriram said?
Definitely, sir. You should, sir. Definitely.
I had a very wonderful experience studying one of the judgments of the Supreme Court. Now, this being a very frank discussion, there's an academic session, we can discuss that. It's download, cut, copy, paste. So I had two situations, I'll tell you. One is a case of a judgment which is reported. It's a reported judgment. I was looking into one of the reports, and I found a case because it is a criminal appeal of a alleged rape case. And so I started reading the judgment. The skeletal facts were mentioned, but of course it did not really catch on the crucial issues. It started elaborating on judgments and judgments and judgments which are precedent law. One after the other, the precedents started being quoted, and everything was on the fundamental principle which we normally say in the Indian context: a rural Indian woman will not make a false statement, and even if a late complaint is made by her, it's only her chastity is the greatest, and all those things. It's that principle, Bharata Nari Stridan Shuddhi and all those things. This is a fundamental principle, and this is reiterated. About 20 judgments are quoted in that one judgment. So I also thought, why this so much of repetition? The same thing happens. Then I found, with great respect, and no mentioning names here, out of the 20, 18 were by the same judge.
We know who he is.
No, I will not say that.
You are
going to get another shell bomb from me now. Ultimately, I found all this is attributed to a victim who was 1.5 years old. The case of a victim 1.5 years old. I will carry this example to my grave, so long as my conscience is there with me when I am asked to adjudicate or speak on these adjudication matters. The second instance is that also flags off another issue. With great respect to the lot of youngsters I am told are in this link now, there is a system of what is called the law clerks. There is a system of interns. Even I had law clerks and interns and all that. You have to give them opportunity. You have to groom them. Grooming them is very important. Rather than, it's not hire and fire. It should be grooming them also. Grooming them and utilizing them, both are there. One gentleman was to deliver a speech on mediation. Mediation in India at those days, of course, I had the opportunity to touch on that subject in almost all the high courts where I worked. This gentleman delivered the speech. The concluding paragraph, he quoted Swami Vivekananda. So I thought, how does the Swami Vivekananda? I can understand so many other Panchayat Raj system and other things of the olden days coming in between. In fact, the quotation was by Swami Vivekananda on meditation. And this Chotu, this law clerk, he included that in this, and this was read out. This was read out. With great respect, I am saying this. See, we are judges. There are judges here. There are practicing lawyers in this link. There are the future generation is also linked, the law students. let me tell you, I am sure if Justice Ramakrishnan writes a judgment, or if one judgment is written and published as that of Justice Ramkumar, and if there is some error, neither Justice Ramakrishnan nor Justice Ramkumar nor Justice Thottathil Radhakrishnan can turn around and say, no, that was my private secretary's mistake, my shorthand writer's mistake. No, you are the father and author. You can't cut the umbilical cord that way. So that's a great principle which the youngsters should know. You have to, once you have fathered the child, you have to hold him. You can't simply say that my private secretary did it, my shorthand writer did it, my court clerk did not look into it. Thank you. That's just an addition to what was being now put across. Thank you.
Thank you, Sriram sir, for triggering that. And
I wrote an article stating that a particular judgment of the Supreme Court saying that Article 360 CRPC is applicable to that state is wrong, saying because the Probation of Offenders Act 1958 had been extended to that state. Thereafter, 360 has no application at all. Supreme Court itself has held that. And the reply came not from the judge or from anybody close, but from the law clerk.
Yes, it's all Lokita.
Yes, it's a locket, no doubt. Prasad sir, your hands are up. You have something to say, please.
Yeah. First, I am extremely happy to see our former Chief Justice. I am really thankful for the opportunity. Sir, I have a small doubt. Kindly don't misunderstand me. Sir, once the requisite court fees is paid and the case is numbered, obviously, I feel that it is the responsibility of the court to ensure its disposal. Why don't we have a proper listing policy? Particularly in the changing times, we find it extremely difficult to get the cases listed, and we do not know which case would have the overriding priority over the other. Of course, even in the previous days also, we had suffered from the same problem. We have to compete with each other for making a mention. Fortunately, we may get a case listed. But always a doubt lingers. Why can't particularly the high courts have a listing policy of these cases so that at least even if they are not exactly following the queue, one day or the other there would be some kind of assurance that it would be disposed of.
Shall I just straight away give my response to this? I will flag off that by saying that my parent High Court is the Kerala High Court. The Kerala High Court has a system in place, which I am sure is a matter of record, because I had taken out those materials for the purpose of the other High Courts where I had been the Chief Justice, and I passed it on to them to work on it. We have a system in the Kerala High Court where matters in the High Court, I'm saying, the matters which are filed today will be taken up either the next day or the day thereafter on the basis of a direction which is already in place. So there is a principle of a rule which the administration cannot get over. And mentioning is not permitted in any matter unless it is exceptionally urgent and it cannot wait for the next day. This is in the High Court. So far as the trial courts are concerned, normally there is a rotation of the courts of the cases to be listed before the different benches of the same jurisdiction. If there are 10 subordinate judges, there will be 10 rotation matter, and this will necessarily come. These are all governed by rules and procedures. The failure that I see is there is no adherence to the rules and procedures. If the bar has a collective lot, not to have a hullabaloo on it, but if it is pointed out through the elected representatives of the bar or even otherwise to the appropriate level in the High Court or the District Court, I'm sure that this can be easily rectified. And now Kerala High Court system is now being looked into as a guiding example by different high courts, including the Calcutta High Court. I've given it to them because it's a very clean system. It doesn't make a distinction between how many people are actually, who is a lawyer and who is mentioning, nothing. because Calcutta has a huge problem of this mentioning. First, Chief Justice's court early morning looks like something like a huge market for every little thing. But now there will be a system, I hope, because the Kerala, if you can look at Mr. Prasad, I'm sure that you are from the Hyderabad, Telengana area. If you can look at the Kerala system, definitely there are orders of the Chief Justice which completely govern. That will be available. I'm sure there are other judges of the Kerala High Court who have demitted office here. These are available with what is called the Registrar Judicial. There is a department called Registrar Judicial. That department has it. It is just a 1 page or a 1.5 page system. It's very simple language. Nobody can run out from that rule book. If you file before 12 o'clock today, you get it on board tomorrow. If you file it before 12 o'clock today and if tomorrow is a holiday, you can get it at 1:45 today itself. So this is a system which is already in place. It doesn't depend upon what's the court fee you have paid. But once the matter is taken, but there's one small addition to what you said the judiciary has got a authority, duty to dispose it of. But all these are only to ensure that the judiciary takes up the matter. It comes up before the court. Once it comes up before the court, adjourning a case, posting a case, hearing a case, and deciding becomes a judicial activity. It will be passed on judicial orders. They are judicial functions. The first administrative function of putting it before the judiciary, putting it on the bench before the judges, really operate on the basis of guidelines which are in place. The problem is that if it is not enforced, you have to push it and get it done. I am sure that having seen good lot of Chief Justices, almost any such complaint will be attended to without delay. Thank you.
As regards the trial courts are concerned, within 3 days it will come. Whether it will be defect is to be done, returned, everything will be done within 3 days.
And we have the odd number,
also,
even number, even number filing.
Even number, it will go to the, suppose more than one court is there, it will go to the other courts.
Of course, lawyers used to defeat that by filing dummy cases.
That is a different thing, but we are not on the system. How it is being misused is a different thing.
In fact, Ashok Manan sir, I believe, was in charge of that for quite some time, I believe.
Yes. So it's never delayed. Kerala High Court is prompt. And even if there is any delay in filing the application to take it up early, even that can be condoned to some extent by the Registrar General and taken up.
In 10 days they can do it.
Yes. So if that is strictly followed, I think there will be absolutely no delay in taking up matters.
The question in the High Court is not that. What happens is subordinate court, there is a date is provided, so on that the case will come. But in the High Court, there is no date, and the steps are not taken within time. And the registrar in charge will be having some time for the purpose of condoning and regulating it. After that period is over, it has expected to come to the bench. But most of the time it never comes. There is a whole difficulty in the High Court. As a trial court judge coming to the High Court, what I find from the difficulty is this.
No,
that causes the delay. That causes the delay in making the cases ready for disposal. That is one thing.
After this computerization, now we are supposed to give a date. It is mandatory. Every adjournment is with a date in the High Court also.
No, I think that came.
No, it was not there. Take after 3 weeks. Take after 2 weeks was there. But now, because of the computerization, now they are insisting on dates. So we give a date, and it is usually posted. But what happens is sometimes the posting is so heavy that some of the judges restrict it to 50 matters or 100 matters, whatever it is. Then if it goes beyond that, then it is not taken up. That is what happens. Otherwise, it will be taken up.
In that number, you get the alert also, SMS.
No, the thing was when I was in the High Court dealing with the first appeals, I find that more than 200 appeals which has been disposed of has settled out of court or become infructuous. When I asked the office to find out the defect and post the defect case, that is the things happening. And that started because after I think that NP Singh was the Chief Justice said that in order to meet the situation, every bench must have at least 10 to 15 defect cases to be posted to find out what is the reason for old cases not coming up. The things are depends upon how it is being met.
Absolutely.
Mr. Shyam,
Yeah.
can I just use this situation created by Justice Ramakrishnan
Yes.
for a small clip to the youngsters? See this defect list. I just immediately recalled two judges. One was Justice Balanarayana Marar. He is no more. He passed away after retirement. He and then Justice Krishnan Undi. He is also no more. I think he died while in office. Second appeals and single first appeals used to be posted before them for the defect list. So normally the lawyering culture of Kerala High Court those days, the juniors in the office will come to the court and say, Lordship, 2 weeks time may be granted for curing defect. So for curing, because it was posted before the registrar concerned, this fellow doesn't appear, therefore it comes on the judicial side, and before the judge he says 2 weeks may be granted. And judges used to very casually, with great respect, casually adjourn the matter. Okay, 2 weeks. Okay, 2 weeks. Sometimes with a little bit of anger, they will say, okay, 2 weeks last chance. 2 weeks, no further time. So this used to happen. But then when Justice Marar and Justice Uni came, Krishnan Uni came, they had a different modality, particularly Justice Balanarayana Marar. He will ask the youngster, what is the defect? Initially, no junior was able to say what is the defect because the clerk has actually told him in his ear, just ask for 2 weeks time. The clerk also does not know what is the defect. And this fellow is expected to cure the defect. Justice Marar used to adjourn the matter for after lunch session or the next day. He will say, go to the section, find out the defect and come and tell me what is the defect. Then I will grant you time, but you should come. Don't send somebody else. So what happened is, this little fellow, Chotu, he gets time, this junior gets not only time, he gets the opportunity to learn what is a defect. How do you correct the defect? What is a defect? Which provision of CPC? Because next day when he comes to Justice Marar, Justice Marar will open the CPC, or he will open the civil rules of practice, or he will open the High Court rules. So this is the modality in which the judges were involved in training the young lawyers. I think we need to cope up. I still remember, off the cuff, I can tell you, I was enrolled in 83 December. I started in Trivandrum. One day in an executing court which deal with execution matters after lunch, I was standing there from our office and the office clerk came and told me, a very elderly person, he came and said, sir, please ask for time. I said, for what? He said, defect not cured. But I knew that judicial officer of such breed and brand, she will definitely ask you what is the defect. I know the name of the judge, I will not now mention it. She used to say, what is the defect? So I asked him, what is the defect? This gentleman did not know. Ultimately, he said, something Malayalam, he told me something. I said, and I, poor fellow, had not studied Malayalam to that extent in Kerala to understand what is Morashaguli, though I know Malayalam very well. So I didn't know how to communicate to this officer by saying Morashaguli is not deposited. So immediately, I still recall one of the celebrated seniors, Venkatachalam Iyer. If somebody from Trivandrum is linked or some judge who had presided at Trivandrum
Father
court.
V. Suresh.
Suresh's father. V.
Suresh.
Suresh's father. V. Suresh, whom I wanted to migrate to Ernakulam and argue in the High Court. He refused on my face. Poor fellow. I mean, great respect to him. His father came to that court. I asked him, Sami, Morashaguri, and the tom charges. So I got up and said, tom charges not deposited. Oh, what a goal it was on the face of the judge. Judge was so happy. So this is how the youngsters get the opportunity. The judges create opportunity, give it to them, bring them. So this is how I think I wanted to intervene only to say that this defect curing mechanism is a great platform for the youngsters to learn the fundamentals of procedure. Thank you.
We have heard that Justice P.T. Raman Nair, who came from the executive, used to do the same thing. During my time, Justice G. Vishwanath Iyer, he would never spare a junior as to what exactly is he would ask him what the defect is, see that it is cured, and he will teach him the CPC provisions.
Just like Justice Rajendran sir want, we will somehow or other get it to 6:30. I think we have crossed 6:30 and we are at 6:40. Not to look into the watch, sir, but he has already won, and that is the beauty of this platform, sir. We don't know how time flies because we get involved in this sort of interactions, and it empowers and enlightens everybody because everybody gets involved. So as we come to the end of the 250th session, may I request K.V.J. Rao sir to render the concluding remarks.
Good evening, everybody. I thought we had a program yesterday, but I called up Shyam sir and he said, no, I don't want to spoil the 250th session where we have a very important person who will come and speak. And sir, with due respect, it was an honor to listen to you. I should say we are blessed to have Chief Justice like you who can come onto this platform and be so candid as to where the flaw lies, and being candid to where the flaw lies is one thing, but to also try and provide solutions to it is a bigger element that comes out when we hear you today. And I thank you very much, sir. It's really been nice. It's pleasant. And as Sriram sir said, every lawyer is walking that fine line between contempt and pleasing the judge. So that is also another issue that definitely needs to be considered. Having said that, as Mr. Menon said, the CMIS system, when a matter is not taken up, it automatically goes to the computer management system. Now that will give you a date, maybe 6 months or 7 months, because of the algorithm that it is fed in. So that will again create a problem where a mentioning will take place or there will be an application made. So rather than the CMIs give a date of cases that have not been taken up for obvious reasons, that the board was heavy, why not factor in that, okay, if it came in today and it was not heard, we'll take it maybe 15 days from now, it will come on to the board. Because if it goes for 6 months, then we are putting pressure, as you said, the mentioning of cases at 11 o'clock in the morning, it is really like people clamoring over each other to be heard first. So maybe if we could inculcate the system, put it into the system, then we may not have a problem. And as you rightly said, sir, the trial court is a court where the polishing of a diamond will take place. The shining will come only in the High Court, because once the trial court has, the arguments are good in the trial court, you will not have a problem in the High Court. As Justice Ramakrishnan said, the written statements are repeated over and over again. It makes really, I agree with him. It makes no, does not help anybody that you give something voluminous to read when the same thing can be said in 4 sentences. But they don't want to, but if they give it to you in 4 sentences, they're scared they may lose the case. So what they do is this is a strategy called search the needle in the haystack. So you give a voluminous presentation and you come up with 2 or 3 points, and then you expect the learned or the honorable judge to go through your whole written submission. It is not definitely possible. And sometimes, sir, what happens is even in trial court, when an application is given, they say opposite party to say. Now, sometimes you don't want to put things in writing, but you want to orally say it because it has more effect. But the trial court learned magistrate or the learned ACCM will insist that you give it in writing. So that's also like, because whatever I give in writing might most probably go into the order passed. So what I would be saying orally also would have to be recorded in the order. So that's another issue. But sir, to sum up today's session, sir, it was really a pleasure to hear you, really a pleasure having you. And we thank you very much, sir, for taking your time off to come and educate us. Thank you very much, sir.
Rahul sir, the Littles family is privileged to have all of you wonderful family members, extended family and otherwise in this 250th session. And thank you, Thottathil sir, for agreeing and gracing the occasion and sharing your thoughts with us. Beneficial to all, including the student community who have taken time to attend today. We are also privileged that we could have Justice Ram Kumar sir, Ram Krishnan sir, Justice Ashok Menon sir, Kunjikrishan sir, Niyaz sir, and I'd say P.S. Narayana sir, and all of you, Sriram sir, especially thanks to you for taking time out, and I'm sure that you'll be here next time also. Let us say that all these deliberations and discussions, let there be a positive outcome. Let us put our mind to it. Maybe all the stakeholders, if they come together, there might be a possibility that instead of pointing fingers or accusing, we can all come together and find a way out wherein the justice dispensation machinery could be strengthened, and we can have a better, COVID have taught us that the new normal is not what the normal is, or changing times require an altogether changed outlook, approach, everything. So thank you very much for sharing your thoughts, your experience, so that all of us could think, contemplate, and are benefited also. We hope that you will be there with us in the forthcoming sessions as well, in the sense like you're part of our family, and I'm sure that whenever time permits, do drop in so that we can have exchange of ideas and thoughts, so that all of us can have some sort of interaction.
Before closing, in a lighter way, I was attending a webinar, taking classes on the NGTs, the role of NGT in protecting environment for a NGO from 3 to 4:30. I got the call of Shyam Padman. Only because of the platform which is available, I was able to finish that and come to join this platform also. There is one advantage we have because of the virtual system. Otherwise, we will not be able to do these things. Attending several matters.
Distance is no problem.
Distance is not a problem at all.
For that matter, Justice Ram Kumar sir will be in Punjab and Haryana tomorrow.
No, I was addressing a group in Kannur district of my own my own native district. But coming to Chennai and again attending the Ernakulam where the Shyam Padman is conducting this program. So it's a wonderful thing that is happening because of the pandemic only. We will have to thank pandemic for giving such an opportunity also.
Yes.
It's like
Absolutely, sir. It's just like saying there is nothing good or bad about the technology. How you wield it, how you use it. It can be destructive, it can be constructive.
I was finding it difficult when the COVID came. People were asking, sir, sitting is not happening. How to do it? Lockdown, courts are not going. Things are not done. We will have to find out some method because I am not very particular about the technology. I do not know how to do it. So I will have to depend on the technology, my person, to say that whether anything can be possible to promote this. Then he said that this can be possible. So we will have to do it. We are compelled to do certain things when opportunity gives or our challenges comes. We will have to take it as an opportunity to meet the situation. That is what is required in the situation.
Thank you, Ramesh sir. Thank you all of you. A Sunday afternoon well spent, Sunday evening well spent.
Thank you.
Thanks. Safe. Thank you very much.